assumes the evidence is coming in, and I don't make that assumption since the motions are still outstanding.
I'm trying to cover things in terms of eventualities and, you know, conditionally and things like that. So I understand that. I hope you're not chewing gum. Are you chewing gum? Okay, great. No chewing gum in class. All right. So it's my understanding that everybody has joined in the position that Mr. Copeland's testimony was coerced based on what occurred during the June 10th ex parte. So, and yet I know at least some of you want that testimony and said that yesterday. So are you waiving the issue of its potential coercion?
And good morning again, Your Honor. I am not waiving that
All right,
issue.
so then how do we handle that?
I thought it's two-stage. I was answering your question. If Mr. Copeland's resumes testimony, then my understanding of the rule is, or the law, is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is excluded, and we redo it. And that's what we, Mr. Atkins sent an email last night. That's what three of us responded to. I don't want to waive, though, the issue. I thought we should have a hearing with Mr. Copeland to determine did that in camera, if it's in camera, ex parte rather, June 10th meeting, did you feel intimidated, coerced under the Archer case, which from Maryland, I know it's from Maryland,
Right.
that we discussed? And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to testify. You know, he could choose what he wants to do, and then we would strike everything he
Okay,
said.
well then let's go ahead and find that out. I mean, can you get him here so that we can explore that issue? Because here's the thing is that, yeah, if you know, everything after June 10th, whether the recusal motion was filed or not, that's kind of a separate issue from whether his testimony post June 10th ex parte meeting was coerced. And if it was coerced, then what then? Then how do we still say, oh yeah, but I want, you know, some of that testimony? That's still good.
I thought you, and listen, I have so many, you know, going on. It's just the reality of our case.
Yeah.
But I thought you said that either yesterday or last week that we will find out whether Mr. Copeland actually wants to testify, continue testifying, and then if he doesn't continue testifying, my understanding of the law is then he would never have been given an opportunity to be cross-examined.
Right.
And therefore you strike all of his testimony. Then you give the command to the jury that wipe out everything that you heard, saw. There were writings introduced, all exhibits are struck, give me your notes.
Right.
That's what I thought. Now,
Okay, I just didn't understand because, you know, and thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position it was coerced, you know, we have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a yes, if it was coerced, then we need to redo all of it, or, you know, find out, does he at this point kind of redo are you intending to take a stand and testify, or are you going to be held in contempt?
that's what I thought.
Okay, all right. Just so sounds like then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways. Ms. Levy, you look like you want to say something.
I was trying to get a full grasp, Your Honor, on everything that was being said. And when I hear that we're looking into whether or not his testimony was coerced, of course I'm going to defer to the court. I would object to that for several reasons. One of which is that the opportunity to review what went on there. And I believe that based on what is there, right there, on the transcript, the court can see, and I believe could make a determination that there's not coercion. So based on the way that the witness has conducted himself, and based on the concerns that we have expressed, the concerns that the witness expressed during prior interviews before I even came onto the case, I would ask that the court not revisit or go back and see if, have a hearing on whether or not he felt coerced.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial and in Mr. Shart's, on Mr. Stillwell's behalf, revised motion for a fair trial. That's a big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but, and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway, but.
And so for those reasons, I would ask the court to not have us bring him in before that time that he has to testify. I'd also point out that his counsel was present.
I know.
So thank you for hearing me.
Okay, well, I mean, I hope that it is not up for debate that some of what was said to Mr. Copeland in terms of potential ramifications if he didn't testify was incorrect. I don't think that there was any kind of, purposeful or nefarious motive in that. But I mean, at least with regard to the notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. But I mean, I also don't think that he paid much attention to that at all. He doesn't even seem to have, he kind of basically moved on from that, but that was incorrect. I think that some of the assertions about statute of limitations potentially were incorrect. I don't think that with regard to he seemed to be worried about a particular crime, the statute of which had apparently already run. But I think that in terms of the notion that he faced no potential jeopardy with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all are basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting over here charged with RICO for crimes, the statute of which, when the statute has run on the overt acts, they're in support of the RICO.